and welcome to Accessible Law. My name is Mike Maslanka, and I'm an assistant professor of law here at UNT Dallas College of Law. Today, I would like to talk about unlawful discrimination against an employee who is associated with a person who is considered disabled under the Americans with Disabilities Act. Let's call it the ADA for short. First, let's look at the ADA from a 30,000-foot perspective. The ADA became law in 1990 and prohibited discrimination against those with disabilities. The ADA got a major facelift from Congress in 2008. The law covers 40 million Americans. That's right, 40 million. Now, both versions of the law contain a prohibition against discrimination against an employee who is associated with a disabled person. Let's read the language of the law together. It is unlawful for a covered entity to exclude or deny equal jobs or benefits to, or otherwise discriminate against, an employee because of the known disability of an individual with whom the employee is known to have a family, business, social, or other relationship or association. Okay, let's translate. What's a covered entity? That's an employer with 15 or more employees. A person with a disability, that's one of the 40 million people we talked about earlier. And a disability covers everything from cancer to infertility to heart ailments and so much more. But note, under the law, the employer must know that the employee is associated with such a disabled person. And what does association mean? Notice how broadly the law is written. The association can be based on all sorts of relationships: family, business, or social. And here's the whopper that Congress put in the law. The law also protects other relationships or associations. Now that covers a lot of territory, and Congress meant it to. When the law was proposed, Congress rejected an effort to limit association to relatives by blood, marriage, or adoption. So the idea of association encompasses, for example, discrimination against an employee who does volunteer work with an AIDS patient based upon a fear that the employee poses a risk to fellow employees because of that association. Now, what situations most often arise that trigger the protections of the law? There are three. Here's the first. When an employer fires an employee or takes discriminatory action against them because the employee has a seriously ill family member and the employer is concerned about increased medical premiums. The second is called the distraction theory. Now, the distraction theory is triggered when an employer takes an adverse employment action against an employee because the employer assumes that the employee won't be able to concentrate at work, or that the employee will miss too much work attending to the needs of, say, a family member. Here's the bottom line. Assumptions are not allowed. Now, what's the third? The employer believes that the employee will catch the same disease or ailment as a person with whom they're associated. Now, there are a couple things to keep in mind. First, an employee is still required to satisfy the attendance and tardiness policies of their employer. Absence due to caring for the disability and the person with the disability is not protected, although the employee may be able to use the Family and Medical Leave Act to do so in certain circumstances. And also, second, the employee is not entitled to any accommodation to take care of the person with a disability. What do you do if you think your employer has violated the law? You must, absolutely must, file a complaint with the EEOC, that's the Equal Employment Opportunity Commission, within 300 days of the date that you believe you were the subject of discrimination, or within 180 days with the Texas Workforce Commission. These agencies will investigate and often attempt a resolution. The key point, you must file the complaint with one of these agencies before you bring a lawsuit. And I'm going to end on this. It's a final point, but it's a very important one. As we teach our law students, make sure you don't just understand the law, but why we have the law. Why this law? Congress understood that the disabled often live in unnecessary shame and fear because of their disability. So it wanted to make sure that their support networks remained intact. Thanks so much for watching. This is Accessible Law.